Good evening, one and all. And amongst us, we have Nilima Bhadbhade ma'am, as fondly known by students and others also. The professionals also are too happy to be learned from her. And Specific Performance 2018 Act amendments has given different facets. And if you Google around, you'll find ma'am has a specific contribution towards this particular act and the way how to understand the things. I request ma'am to share her insights, and we are too glad to call her, request her to be on this platform time and again, and she is always readily acceding to our request.
Thank you so much, Vikasji. It's not just a pleasure to join, to speak on your channel, but also to visit all the other videos that have been put up by experts, judges, lawyers, and so many others. Whenever I find time, I do listen to them, and I especially enjoy listening to insights on the law of evidence. Thank you for inviting me, and namaste to all of you from all over India. The topic today is how do we look at the relief of specific performance after the amendment effective from 1st of October 2018. And before I proceed, I would like to ask Vikasji, can you hear me well? And can you see the presentation?
Yes, ma'am, both are fine.
Very good. So what we do in today's session is to look at specific performance, which is no longer an exceptional or discretionary remedy. It's a general remedy, and it is only subject to sections 14 and 16. Has the slide changed, Vikasji? Yes.
Yes, ma'am.
Yes. Then a very important part of that change is that the remedy is no longer discretionary. So the court does not exercise discretion. On the other hand, the amendment provides for a new remedy of what it calls substituted performance. And we will see how that is a good way instead of asking for specific performance itself. And another important aspect, which probably has not been discussed anywhere, is that compensation in substitution is no longer available in the section relating to compensation. So broadly, these are the four aspects which I will cover. My presentation is restricted to the relief of specific performance. Now, when we go for a relief of specific performance, it is basically a remedy, one of the remedies for breach of contract. Therefore, a plaintiff who asks for specific performance, and there may be some situations where a defendant asks for it, very rare, but whenever, even when the defendant asks for specific performance, I will still call him the plaintiff. He is the person who asks for specific performance. So this plaintiff has to establish that there is a breach. In specific performance language, we refer to it as refusal to perform. So the plaintiff has to first of all establish, that is, plead and prove that there is a valid contract between the parties. Then he will have to show which part is left for performance for which he has come to court. So he will either say it is broken, or he will use another terminology that I am willing and the defendant is not performing. So there's a refusal to perform. And then he has to show that the other party has not performed what he has agreed, and that is the breach. Now, this aspect has to be shown by the plaintiff, whether the case is for specific performance or it is for compensation. So this is the common part. Now we have to look at section 9 in the chapter of specific performance, which says that a plaintiff who has to establish breach to him, in his case, the defendant can forward any defense which is available to him under the contract law. This is the section. And the last part, the last two lines say that he may plead by way of defense any ground which is available to him under the law relating to contracts. This is actually the substantive part of claiming the remedy. So if a plaintiff says here is a contract and it is broken, the other party may say that there is a mistake. I come to the later part of the slide. The other party may say that there is an uncertainty and therefore the agreement is void, that there is an illegality, that there is material alteration, that there is an impossibility, a subsequent impossibility which discharges the contract, that the performance has been remitted, that parties have substituted a new contract, that parties have altered the terms of the contract, and therefore the term which is stated to be broken was actually altered, that the plaintiff himself has failed to perform the contract, and therefore I am no longer liable to perform, that the plaintiff has broken the contract, and therefore he cannot claim compensation or he cannot claim relief, that I have validly rescinded the contract because the consent is not free, or because there are breaches elicited in sections 39, 53, and 55 of the Contract Act, or he has terminated the contract according to the provisions in the contract, and so on. So basically, he has to show that now that this has happened and the defendant has raised a defense, so it falls upon the court to see whether the defense operates and what is its effects on the plaintiff's claim. And if the plaintiff shows that the contract is valid and the defense is no longer available, which the defendant has to prove, then only we proceed towards the relief. And therefore, we have this suit for specific performance or compensation in two stages. The first stage is show under the contract law that you are entitled to the relief. And then we go to the relief itself and see whether the requirements of that relief are fulfilled or not. These two stages, I will be coming to these two stages again later, but we bear in mind that this works in two stages. Now, when he asks for that relief, the next question in stage number 2 or phase number 2 is, does he fulfill the requirements of granting the relief? Granting the relief, the provisions of law take into account the interests of both parties. So when it comes to the claim for compensation, the plaintiff is required to show that the breach has caused the loss. First, of course, he has to show that there is a loss, but the breach has caused it, which I call causation. Then he has to show that the loss is either natural or it was within the contemplation of parties. I've used the word foreseeability. What I mean is contemplation of parties. And third, the defendant will try to show that the plaintiff has not mitigated, he having the obligation to mitigate. So it may happen that the plaintiff shows that he has suffered a loss of 1 crore rupees because of the breach, and he actually is able to show that it is because of the breach. He will not be entitled to get that 1 crore rupees because there are 2 more conditions to fulfill. And these conditions, if they arise, then the amount of loss will get reduced. What I mean to say is that even if the plaintiff suffers this whole loss, whether he will get it or not depends on the conditions for granting that relief, which we find in section 73 of the Contract Act. Now, when it comes to specific performance or injunction under a contract, we apply the Specific Relief Act. So what were these requirements for that relief under the Specific Relief Act before 2018? I am just using before 2018 and after 2018. The date is 1st of October 2018, and that came by an Amendment Act of 2018. So before 2018, he had to show that compensation would not have been enough, that it is inadequate. And this was given in section 10. Then he had to show that the contract is of such a nature that it can be effectively enforced. This was the requirement of section 14. Then his own personal conduct, as he violated an essential term, is he ready and willing, which is section number 16. And that even despite all these hurdles, even if he has fulfilled, the grant of the relief fell within the discretion of the court. And this was under section 20. And many criteria were given which the courts must consider while granting the relief in the matter of discretion. Now, what has happened after 2018? After 2018, the test of inadequacy in section 10 has gone away. So if you want specific performance, ask for it. That's all. The test of effective enforcement, which I will deal in detail later, still remains, but it is modified. And the plaintiff's own conduct is still relevant. And there's a small change in the requirement of readiness and willingness, which actually makes it easy for the plaintiff. So these are the conditions subject to which the relief is granted. So a person may say that, yes, now that the contract is broken, give me my relief. And the law says, wait, there are other conditions which we must see, then only you will get that relief. This is the phase 2 of the grant of reliefs in contracts. So let us come to the relief of specific performance. What is meant by specific performance? The plaintiff asks the court to grant an order that he will get what is exactly promised under the contract. So, if he has agreed to purchase goods and the defendant has broken, the supplier has broken the contract, then he might go into the market and buy them and claim the difference in price. Means he is not claiming what he's agreed, but he's getting the loss. However, if he's able to get an order that the defendant must supply the goods, he must do what has been agreed, then this is the order of specific performance. So the essence of it is that the promisee must get what has been promised to him. So here, in the order, there is a compulsion on the promiser to perform the promise. So the order says, Mr. Defendant, you are hereby ordered to do these things, sign the sale deed, etc., etc. So order may either be you sell the property, transfer the property, or the order will be, Mr. Defendant, you deliver these goods to the plaintiff, or the order could be that, Mr. Defendant, you construct the building according to this plan. And here, the order is against the defendant, who is the promisor who gave the promise. So, Mr. Defendant, you sign the sale deed. So the defendant is hereby ordered to do these things. It's an order against the promisor. Now I come back to my first point in the slide. The real question is, the promisee should get what he has promised. Is there any other way in which it can be achieved? This is what we ask. Why run after the promiser? If I can get the promise performed, then what is the problem? I will hold the promiser liable later on. Okay. So here we are talking of the promisee getting the promise, but not through the promiser. Somebody, he's getting it done himself. And this aspect of specific performance, that the promisee gets what he's promised, but not necessarily from the promiser. This aspect is dealt with in the new remedy, substituted performance. So promisee obtains the performance, but from a third party, right? Then he has a claim against the promiser later. So this is substituted performance. And I'll be speaking about that too, because ultimately, what is specific performance? If I am the plaintiff, I want what is promised. And there are two ways of getting it done. And these are the two ways which we will see. Let us look at the sections relating to specific performance. I'm only taking those sections which are changed and which are material for our discussion. Section 10 of the Specific Relief Act provided about specific performance. Vikasji, has the slide changed because my mobile probably is slow?
Yes, ma'am.
Yes, very good. So now section 10 dealt with cases in which...
It continues with the comparison only.
I don't know, but on my screen it has changed.
It shows specific performance promisee gets what it was.
So this is slow. What shall I do?
Just skip it. It will
Very well. I will keep talking. The slide will come. Let me see if I have to remove the burden on my computer by closing some programs. Then, okay. Okay. Section 10 referred to cases in which specific performance of the contract was enforceable. Cases in which. And then it said that there are two things. One, in clause A, it said, when there exists no standard for ascertaining the actual damage caused by the performance of the act. No standard for ascertaining means that compensation is unascertainable. And the second is clause B, when the act agreed to be done is such that compensation in money for its non-performance would not afford adequate relief. Here we are talking of inadequate. So even if compensation is paid, it will not be adequate. And therefore, this test of inadequacy was about not being able to ascertain compensation, or even if compensation is granted, it will not be adequate. This I call, and it's called in many academic writings as the inadequacy test. Some writings also call it the adequacy test. What does it mean? It means come and ask for specific performance only if compensation is not an adequate relief. And then in the explanation, there was a presumption. And I refer you to the last part of the slide where there was a strong presumption in case of contracts to transfer immovable property that compensation will not be adequate. And therefore, if there was a contract to transfer immovable property, like an agreement of sale, then the purchaser could have asked for and likely to get specific performance because of the operation of this presumption. So let us move further. This made the nature of the remedy exceptional before 2018. This is the threshold test of inadequacy under section 18. What is that threshold test? 1, compensation is unascertainable. It means that you just can't prove the loss. So there is an antique item and you can't prove the loss. Here, this situation arises where the subject matter is either unique or where it is of special value to the plaintiff. Unique, special value, two important words. So let us suppose that I have agreed to buy a shirt. Now, an agreement to buy an ordinary shirt, I mean, it's compensable. An agreement to buy a shirt, which a very well-known singer used to wear in concerts 40 years ago. This is a unique subject matter. And then otherwise, there is a shirt which used to belong to my great-grandfather. If I get into the market, it won't fetch me anything. But for me, it has special value. So it should be unique or it should be of special value. This is what makes compensation unascertainable. The second is where compensation would be inadequate, which means that you can't obtain a substitute. obtaining the substitute would be costly. Even if you give the substitute, there will be something more which the person has lost. Such cases come under what is called compensation is inadequate. This happens when especially goods, they are available in the market, but not ordinarily available. It is not an ordinary article of commerce. It's not usually sold in the market. Such items, therefore, compensation is inadequate. Vikasji, shall I stop the share and share again?
You can try that, ma'am.
Yes, because I've already moved one slide, but apparently it's not moved.
It has started with the first screen only, ma'am.
I know. Can you help me resolve this problem? Yes, almost there. This is the slide I was talking about.
Yeah.
Right? It is unascertainable or it is inadequate.
Yes, yes.
So let me proceed ahead. There were presumptions before 2018. Is this visible, Vikasji?
Yes, it's visible.
Very good. So presumptions would operate before 2018, that if it's a contract to transfer immovable property, there's a presumption that compensation is inadequate. And if it is movable, then the presumption would apply only if it is not an ordinary article of commerce, not easily available in the market, or it was of special value to the plaintiff. Now, what does it mean in terms of practice? It means that if I am enforcing a contract relating to immovable property, I just ask for that relief. But if I am asking to specifically enforce a contract relating to movable property, that is goods, I must not only plead and prove that this is a contract for transfer of goods, but I must also plead and prove one of these three circumstances, that it's not available in the market, it's of special value to me, and so on. Then only I got specific relief, specific performance. Now, in case of other contracts, why? Because if you go to my first point, this applied only to contracts to transfer property. There are so many other contracts. Typically, there was a contract where it was about giving or handing or giving satellite signals. Now, this is not transfer of property. And then will the presumption apply? Well, there is no presumption. And therefore, one has to go to the general provisions of the section to say that this is inadequate. Now, why was this an exceptional remedy? Let us ask. Why was specific performance an exceptional remedy at all? First reason lies in the history of this distinction between common law and equity courts. The second reason was that if you disobey the order, the only remedy is contempt of court, and this was rather too drastic. The third reason was that this protects the personal liberty, especially in cases where contracts are of a personal nature. The fourth reason is that it is required to balance the interest between the parties, but also interest between the parties for the courts. Look at the cost of enforcement. If the cost is going to be too high, then the courts will not grant it, Then let the parties ask for compensation. And lastly, sometimes it will not be possible to enforce an order to do exactly what has been promised under the contract. These are the reasons. I have an article called Exceptional Nature of Specific Performance. It's on my website. But you just Google Exceptional Nature of Specific Performance Nilima Bhadbhade. And in that, I have discussed many of these reasons. And therefore, before 2018, the procedure was like this. that the plaintiff has to identify the contract and the judge also. So is it a contract to transfer property, or is it some other contract? Is the property movable property, or is it not? So you have to categorize the contract. And then depending on the category, you look at the other requirements and you establish inadequacy. And the burden of proving all this was on the plaintiff. So the plaintiff first had to show that there is a breach. Poor fellow is the victim of breach. And the victim is required to again show that, look, I am entitled to specific performance. So this was the position before 2018. Now, the effect of this test was that a plaintiff cannot choose his remedy. If he wants specific performance, why not give him? Let him judge. Then the burden of showing specific performance was on the victim. Let the contract breaker show that the victim is not entitled to it. And the best and the worst part of it was that obtaining the remedy was uncertain. So if you are a lawyer and a client would come to you and say, can I ask for specific performance? I'm sure none of you could say, yes, of course you will get it. Everyone would have said, well, let us see whether we get it or not. This is the uncertainty. So was this test relevant? Now I come to the study I did as part of my PhD thesis, and I'll just tell you what I observed. I studied about 1,500 judgments, wherever the word inadequacy, irreparable, adequate were used, and they were suits for specific performance. Out of those 1,500 plus judgments involving suits for specific performance, 69 cases talked about the question of inadequacy. So that point was raised. Most cases were about discretion. And then I found that the decision involves inadequacy, but it is decided on other factors. For example, phase 1, which we saw. So inadequacy is not decided. Second, wherever it is decided, it is not on the basis of evidence, but inference. It depended on the perception of the judge. Very often, no reasons were given. And therefore, I would say that the inadequacy test was not really relevant in deciding matters. It only stood as a hurdle, but it wasn't used for deciding matters. In other legal systems, specific performance has been a general remedy. So what is proposed now is ask for specific performance if you like. This anyway is the case in many civil law countries. And many conventions like the CISG or the PECL, they also make available specific performance without making it exceptional. So it's not that the law, now the law is something new. Let us now look at section 10 as amended in 2018. I'll just wait till the slide comes. Section 10.
Ma'am, the screen has gone.
Yes, I'm starting it again because it's important to look at this section. Section 10 now simply says that the specific performance of a contract shall be enforced by the court subject to the provisions contained in subsections 2 of section 11, section 14, and section 16. Right? It is made so simple. You remember the earlier one, the long one? Specific performance of a contract shall be enforced by the court. Means when the plaintiff asks, you give it. But the only thing which will stop its granting is that this grant is subject to 11.2, which is about trusts. So for all of us other than who are enforcing trusts, we just have to look at section 14 and 16. It means that the defendant has only the defenses given in section 7, 14 and 16. So now, this is a general remedy. You can ask for it for any contract. the burden of showing that specific performance should not be granted, which is under section 14 and 16, now falls on the breaker because that becomes his defense. The promisee can choose his remedy because he is the best judge whether he should ask for specific performance or not. He also understands the promiser. For example, if I am the plaintiff, I know whether I will wait. The last one is he will ask only if he can wait. So I will know whether I can wait for 10 years when the decree will be granted and this will be useful for me. I will wait because I know that even if the promisor is ordered, there are ways of enforcing it against him. So let me be the judge if I am the plaintiff. Why should the law preempt, right, my desire to obtain a particular relief? And the best part of it is that very often parties' contractual behavior depends upon how the courts respond to the remedies. So if specific performance is generally available, then perhaps parties will be encouraged to perform rather than to break. This is the observation of in many academic articles of well-known authors, renowned academicians, that if you make this a general remedy, then it will encourage performance. Now, the next part of this is that, okay, specific performance can be granted, but it is very important in any legal system that whatever order the court passes should fulfill two things. There are many, but I'll talk of two things. Number one, will this order be effectively, completely enforced in such a manner that the person who has asked for it will be happy about it? He will be satisfied. So the enforcement must lead to satisfaction of the person in whose favor the decree is granted. And the other is even a broader question. Is it possible to effectively enforce the decree at all? And the third question is costs. So let us look at these now that the slide has come. If courts were unable to enforce their orders, then the prestige and honor of the courts will go. It is so essential to maintain the prestige and honor of courts. Therefore, whatever order is passed, it must be possible of effective enforcement. It should satisfy the decree holder. Secondly, there is an unwilling promiser. How much can you compel him to perform? So we ask, that is the act such that it can be got done by another person? So let me give you an example. If I am ordered to sign a sale deed in your favor, as a specific performance, then somebody else can sign it on my behalf. The commissioner can sign it on my behalf. So the involvement of this unwilling promiser is not required. And such situations where this unwilling promiser need not come are actually good for granting specific performance, because then it will get enforced to the satisfaction of the decree holder. And the other thing about enforcement is that enforcing it shouldn't cost so high that it becomes a burden on the courts. Courts have many more matters to fulfill. So it's a question of cost and time. Now let us look at section 14 from this angle. Section 14 before the amendment had got this clause. What is this clause? Yes, its nature is such. Yes, its nature is such that the court cannot enforce specific performance of its material terms. This language encapsulates what exactly is required by section 14. Can the court actually enforce, means get it executed, specific performance? Okay, this language is no longer there. I will come to that again. So an enforceable decree must be possible. It is for this reason that personal promises are not enforced. So if I had a contract that I will sing for you, Mr. Producer, for the next 1 year and I will not sing for anybody else. If you were to compel me to sing, I will not sing well because I am an unwilling promiser. The second is, even if I were to sing properly, Our relations are so strained that you will never be satisfied with what I do. So this may never satisfy the plaintiff, and therefore personal promises cannot be specifically enforced. Constant supervision of the court is required. It means that the costs of enforcement are too high. A person constructs up to a certain level, the other party says, no, it's not according to contract. So they go back to the court has to decide whether this construction is according to contract or not. The court says this is fine, yes, proceed. The contractor again constructs, again the plaintiff says this is not according to contract. This cannot go on. So constant supervision involves costs. Too many minute details the court cannot go into and assess or judge about them. And this is where we say that under section 14, these contracts will not be specifically enforced. So let us now look at section 14 before the amendment. The following contracts cannot be specifically enforced, namely, a contract for the non-performance of which compensation in money is an adequate relief. This clause A, which is called don't grant compensation if substitutes are available. This is no longer applicable, and it is really very sad. I was a member of the committee which recommended these changes, and we had retained clause A as it is, because universally, when substitutes are available, specific performance is not granted, universally in all systems. But the amendment has taken it away, and this is rather sad. The second clause B says, the contract which runs into such minute or numerous details, which is so dependent on the personal qualification or volition of parties, or otherwise from its nature is such that the court cannot enforce performance of its material terms. So please note the part which is highlighted. A contract which is in its nature determinable, this remains. A contract, the performance of which involves the performance of a continuous duty which the court cannot supervise. This also remains in the law. So now, what has happened post-amendment? It says that the following contracts cannot be specifically enforced. Yeah. Clause A is where the party has obtained substituted performance. This is actually redundant and I will not dwell with it. Clause B is the same as before. Clause C is the same as before, but it removes personal volition. It only retains personal qualifications. So personal volition is where I'm supposed to sing, right? This is my volition that has been removed. Qualification means you're going to see whether my qualifications are important, which is objective. Volition is subjective. So the subjective element in that personal contract is removed. And it says it is so dependent on the personal qualification that the court cannot enforce specific performance. Our earlier clause said the contract is of such a nature that you can't enforce, right? So these are broadly the changes. Now, section 14.3, this is a very important part. Section 14.3, it said that, the earlier part said that if it involves constant supervision, it will not be enforced. And then subsection 3 said that nevertheless, a contract to construct can be enforced. Construction of any building or of any work, right? This is the slide. And then it said that, can you order the defendant to complete the construction? And then it said, yes, if 3 conditions are fulfilled. 1, the work is described in a certain way. 2, the plaintiff has a substantial interest in its performance. And 3rd, and the most important part, was where the defendant has obtained possession of the whole work. Now, where is this important? First of all, this part has been taken away. So before the amendment, a contract to construct could be specifically enforced, even though it involves constant supervision. But after the amendment, the constant supervision rule or exception remains, and we do not know how the courts will interpret this. The problem lies here, that if you are the developer and I have given my land to you to develop, or I have given you land for constructing a building for me, and you are in possession of the land, then I can't even get it done myself. If I've just appointed you as a contractor and you have not proceeded to work, The land is in my possession. I can work and claim from you the difference. But if once you are in possession of the land, I cannot do anything on it unless I get back possession. So at least I had this remedy of compelling you to carry out that work. Please remember, to retrieve possession, one is required to claim in a suit for possession. And therefore, this right to get the building constructed was indeed an extremely important right, which has been taken away by the amendment. And I do not know why this was not recommended. So, Section 14 after 2018 is like this. There is no exception for contracts to construct. This is what we discussed. Second, the contracts which otherwise cannot be enforced could not be enforced earlier. That also is now taken away. So what does this mean? You know, sometimes the terms are uncertain, but they are good enough for compensation. So if I have a contract with you that I will supply you the usual goods, because we have earlier transactions, right? Then this language usual goods is good enough to compensate. But an order stating this cannot be drafted, difficulty in framing an order. So this is a contract which is otherwise valid. The terms are not uncertain enough to enforce a decree of compensation. But the last item, and even though the slides are not moving, I will mention it, that after the suit is filed, if the law changes, so I have agreed to sell you land, and the law has come after the suit is filed, because of which I can no longer sell you or you cannot purchase it, then this is not affected by the doctrine of impossibility. But under the old law, the court could say that we will not grant you specific performance, right? But you are entitled to compensation. This aspect of the law, that there may be circumstances sometimes where the court can't enforce various reasons, this aspect has now been taken away from Section 14. Again, I repeat, this was not the recommendation of the committee. The last item on the slide. Now I come to the third aspect, and that specific performance is no longer a discretionary remedy. Yeah. This was the section. And I read those 1,500 judgments of different high courts involving suits of specific performance. Out of them, more than half of them were decisions where courts did or did not exercise discretion. I mean, that was the issue relating to specific relief argued in the court. We all know that specific performance is the discretionary remedy, and that there are some factors like unfair terms, like unfair advantage, etc., which do not vitiate the contract, but where the court can exercise discretion in order to do justice between the parties. This aspect was a necessary aspect. So let me tell you what the committee had done. These factors of unfair advantage, looking at the terms of the contract at the time of making the contract, or the plaintiff suffering a disadvantage on the basis of terms agreed at the time of making the contract, they were taken from Section 20 and incorporated into Section 14. So what was an element of discretion, we made it a subject matter of refusing a grant, that it's contract of such a nature that you cannot enforce it. And then it was clearly stated that factors after the making of the contract will not be considered by the court. So you look at the making of the contract, look at the terms of the contract, and see whether there's advantage, unfair advantage, etc. And then probably that will be a defense. But anything like rise in prices after the suit is filed or after the contract, Shouldn't the plaintiff get the benefit of those prices? Why give it to the defendant? Now, the whole reason for removing discretion was that when the element is of grant of discretion, when there's an element of grant of discretion, then it becomes very uncertain whether a person will get specific performance or not. So the lawyer is also uncertain, cannot give full advice. The client also is not aware. And, as a part of my study, although it was not based on discretion, there were cases where there are 3 concurrent findings for grant of specific performance, and the Supreme Court exercised discretion in not granting it. What I mean to say is that a person can gamble on litigation. He says, let me go ahead, and let me see, perhaps there is discretion, I will get a remedy sometime. A person who has the clout, the strength, and the finance to go up to the Supreme Court can take a chance that somewhere discretion will be exercised and he will not be liable to specifically perform. So 2 aspects, uncertainty and gambling in litigation. These 2 factors were to be considered. But I will again repeat that although Section 20 has been deleted, the committee had actually recommended incorporating those factors into some other section. Not all of them, but some of them. So what were the recommendations of the expert committee? It gave its report in 2016. First of all, grant specific performance as a routine. Take away the exceptional nature, inadequacy test. Then refuse only in stated performance circumstances that incorporated in Section 14. And when they get incorporated in Section 14, then it is for the defendant to show that the circumstances exist. This is a normal burden of proof. And certain grounds were recommended for refusal of grant. And these were that substitutes are possible. Performance has become impossible after the suit is filed. There is an unforeseen undue hardship if you look at the contract at the time of making it. There's an unfair advantage if you look at the contract at the time of making it. It involves personal volition, continuous duty, or constant supervision, or it would cause undue prejudice to third parties. So these grounds were actually suggested in our report, but they were not accepted in the legislation. So the question is, will the courts continue to exercise discretion? Is discretion good? Well, it renders things uncertain. Should there be a power in the courts to exercise discretion? I would say that judges would not like to give up that power. And therefore, I rather thought that these circumstances should have been in the law so that people know that these are the grounds on which specific performance can be refused. I wonder whether courts will still exercise discretion. They may want to, but we have to wait and see what approach courts will take. Very quickly, in about 5 minutes, I will talk about this new remedy of substituted performance, right? Never mind if the promisor does not perform, I will get it done myself and then claim it from the promisor. So we are substituting the promisor. I don't want the promisor to perform, I'll get it done myself. So my performance will happen, right? But at the liability of the promisor. This is the nature of the remedy. Now, could compensation be claimed on cost or cost of cure basis? What does it mean? There's a faulty performance. I am the plaintiff. I have got that repaired. And now I am claiming all those costs from the defendant. Was that possible? This is an important slide. So let me stop sharing and share again. I'm sorry, but I don't know why slides are not moving. If we go to section 73 of the Contract Act, and illustration F and illustration L, illustration F is like this, that A contracts to repair B's house, receives payment. A repairs the house, but not according to contract. So B can recover the cost of making the repairs conform to the contract. Now here, the cost of repairs are likely to be more than in value or price than the original contract, but that can be recovered. This is called compensation on cost of cure basis. The other is where there's a builder who agreed to erect the house, and then he built the house so badly that it was required to be rebuilt. So I come back to the last part. The cost of rebuilding the house can be claimed, and rebuilding is likely to be at a higher price. Also, there's a cost of demolishing the existing building and putting back the new building, perhaps getting the plans re-sanctioned. All that can be claimed. So it could be claimed. Get it done from outside and then claim. Buy goods from outside and claim the difference. This was also possible. But then why this change is required? This is because when you come under 73, you have to fulfill the requirement of contemplation and mitigation. And therefore, even if a person has spent 75 lakhs of rupees in rebuilding the house, there is never a guarantee that 75 lakh rupees he will receive. So he will not get exactly what he has asked for. That is the uncertainty of the remedy of compensation. So how then there were also risk and cost clauses. What is it? That in the contract, parties would provide that if you don't fulfill the contract, we will get it done from a third party, and whatever are the costs of that, you are liable to pay them. Many government contracts contain this clause. So when the risk and cost clause is there, there's a remarkable judgment of the Supreme Court which says that if this clause is there, then you can claim compensation only on this basis. You cannot claim it on any other basis. But my point is that we're putting a clause in the contract also, subject to that clause, compensation could be claimed. So what is the whole idea of having the remedy of substituted performance? So let us see what this remedy is. Section 20, that is also sad. This section should have been worded 20 capital A, because section 20, which is of discretion, is still applied in pending proceedings. So section 20, there's an option of substituted performance. What does it mean? If I have not fulfilled my contract with you, then you first give me a notice in writing, and you give me at least 30 days, at least 30, and you fix a reasonable time that please do this work within this time. After receiving the notice, if I refuse or if I fail to fulfill it, then you can do it yourself or get it done from a third party. So you can engage another contractor and get it done. And whatever costs and expenses you suffer in getting it done, you can claim from me directly. There is no question of applying section 73, right? Only thing is you can claim it from me only after getting the work done. And further thing is that, all this waiting period, probably you are required to also, there is a compensation or loss arising from the delay, which is an additional loss. Can you claim it? The answer is yes. So even if section 20 is there, you needn't go for section 20. You can still claim it under your ordinary right of claiming compensation. You can also claim compensation in addition to substituted performance, especially relating to delay. So section 20, therefore, that is substituted performance, therefore, is an option. So now very quickly, what is the effect of these amendments to the relief of specific performance? People will realize that what we promise must be fulfilled, and they will probably start fulfilling their promises. If specific performance is granted in many cases, it actually fulfills the expectation that the parties have. Common people say, if I've made a contract, why can't the court order it? That is a simple expectation that gets fulfilled. It is also said that when specific performance is a general remedy, parties are more willing to perform. Otherwise, they can easily say, when they claim compensation, we will see. They are actually encouraged to perform. And this, therefore, enables parties confidence in making their contracts. One of the questions is, will it increase litigation? Not at all. I believe that very few plaintiffs will ask for specific performance. Who will ask for it? Someone who can wait for so many years to get that order and then get it fulfilled from an unwilling person. That person who is the judge of his own interest, that person will ask for it. So I don't think that there will be any increase in litigation because of the change of law. And lastly, when we have provided for substituted performance, our discussion in the committee was like this, that we hope that this remedy of substituted performance is rarely used. But once the remedy is available, parties will be willing to negotiate a resettlement, right? So that the work is done on conditions which are acceptable to both parties. And if this negotiation and settlement happens, then that is actually the success of the provision of substituted performance. So this is about specific performance. There are small amendments in section 21 and section 16, and they are quite good. So I think I can stop my presentation.
Yes, ma'am, we can dispense with the screen sharing.
Yes, I have removed. Will there be questions on chat? Shall I check them?
Yes, sir.
Yes,
There are
let
few
me check.
questions.
I will only
Yes.
answer questions which are about today's session, right?
Yes, ma'am. I can take the question if you feel it is connected. It says,
No, yeah.
in
Sale
2022,
agreement is,
my first question we can take, how to show
Yeah.
readiness and willingness for the purposes of section 53 of the TP Act, whether balance amount of rupees 500 or 500 plus registration and stamp duty, which amounts to rupees 9 lakhs as in 2022, should be available.
53A is part performance of
Yes.
contract. Part performance means the person is actually resisting probably a claim for possession. So readiness is to be shown, which means that I am, one thing is that in connection with specific performance, it has constantly been stated that you need not jingle the money in your pocket, in the sense that you need not show that you have the money. It is enough if you show that you will have the money when the need for it arises. And I think that should be enough for readiness and willingness. Readiness is having access to that amount, and willingness is wanting to pay it. So long as these two things are available, there shouldn't be a problem.
And the screen sharing is not gone.
Is that so?
Or probably you are not on this video. That will be a challenge.
No. My video is there. I don't know what has happened. Custom live streaming service.
Your video is not forthcoming.
But am I visible?
Yeah,
Probably.
Yeah, no, it's fine.
Yeah.
Then the other part, probably that screen sharing of Nilima Bhadbhade, that will continue. Just check it out.
Yes, yes. My video should be visible.
Yes.
No, I'll open the
Yes.
chat. It's got lost. Yes. Then the next one is about section 6 of the Specific Relief Act. I don't think I'll answer it first. Advance legal notice to perform contract is given but not complied and breach is committed. Is it required to give one more notice before filing a suit? If the suit I'm assuming that it's not for substituted performance. Actually, no notice is also required unless the contract requires it. The more notices you give, the more you are able to say that the other party is not willing to do it. But so long as you are able to show breach, notice or no notice, if breach is committed, then the claim for compensation comes. If the contract itself provides that one more opportunity must be given or that notice should be given, then the notice must be given. In all these cases, whether there is breach or not, and whether the notice compliant with the contract is given or not, it is for the court to decide. Then can compensation be claimed if substituted performance is varied? Example, if during substituted performance, marble at a higher cost is installed instead of ceramic tiles. This is actually a problem, Mr. Bhavik Rajani, that I believe that substituted performance must be the same as what has been agreed. And therefore, this remedy is possible to be abused by both parties. So, abuse by one party who is getting it done again means that he'll probably get the better work done at a higher cost or rather material which is of a better quality and therefore higher in terms of value. That is very likely. And then it will be for the court to decide whether that is to be awarded or not. So this possibility of abuse is there. Even by the other party, that is the contractor also can abuse this provision. We have to wait and see how things pan out. Gideon says, ma'am, what if the contractor employed by the cooperative society carrying repairs of building causes damage to individual flat? Can society file SRA suit? This will actually not be a suit for compensation, SRA suit. It will be a simple claim for compensation. I believe that there may be provisions in the contract which say that if any damage is done, then that will be set off from the amount which is owed to the contractor. I suppose such provisions might be there and those can be used. But this is not a specific relief act suit. This is a simple suit for compensation. Then KLE Society's Law Collage. Is the adequacy test done with completely? Wouldn't the substituted performance give an edge to the plaintiff to ensure the better quality performance by taking frivolous objections with the contracting party? The first one is that is the adequacy test done away with completely? The answer is yes. And the current case, which is Katta Sujata Reddy versus Siddham Setti Infra Projects, which is 2023 Supreme Court judgment of Justice Krishna Murari by the bench of 3 judges. It says that Section 10 will apply to contracts which have been made after the amendment. I mean, para 59, as in the Supreme Court cases, it is prospective and cannot apply to transactions that took place prior to its coming into force. So this applies, Section 10 applies only to contracts which are made after 1st of October 2018. As regards the substituted performance question, I totally agree with you. I have answered it just now that yes, it can be abused. I think the questions on chat are over.
2 only short questions for students, young students.
Yes.
Like, what is an adequacy test?
Yeah. The test which I told you is either called the inadequacy test or it's called the adequacy test. What is that test? Before 2018 amendment, can you ask for specific performance? I mean, you ask any ordinary person that if the contract is broken, what do you want? That ordinary person will say, well, I want that the other party should perform it. That's the order the court should give. It's natural. So was that possible? Would the court have given an order telling the defendant to do what he has agreed? And the answer was that no, it's not available unless he showed that compensation will not be adequate. And it will not be adequate in 2 ways. One, you can't ascertain it, or second, it is inadequate. This requirement that the contract should fulfill this test, that compensation is not adequate, therefore give me specific performance. This test was called the inadequacy test. It's a hurdle. So you can't get specific performance just because you ask. This was the position before 2018.
Yeah. And second is, it's more like a definition. What do you mean by substituted performance?
Yeah, okay. The word substituted performance has been manufactured. There is a very good article. I can share it with you later, the link to it, Vikasji, where the author calls it virtual specific performance. Virtually, you get what you want, but you get it by obtaining it from a third party, and then you make the promisor liable for it. It's like asking compensation, but you're asking for the whole amount. You're not saying loss, prove the loss, contemplation, and so on. So what we are saying is that if I have a contract with Vikasji and I have to perform that contract and I don't perform it. If Vikasji gets an order against me, Mrs. Bhadbhade, you must perform. This is the order the court gives against me. This is specific performance. But instead of that, Vikasji can take another route. He gives me a notice and he says that perform within 30 days. And then I don't perform. Then he finds some other contractor. He gets the work done. And after getting the work done, whatever are the costs and expenses, he can claim from me. Now, if I am actually gone into liquidation, he will not get that also. That's another matter. But he's confident enough that he will get it from me. So he gets it done. What happens is that if he wants to have his building constructed, then instead of having it constructed after 15 years, he gets it constructed immediately. And that is the main thing. So performance happens very close to the performance date rather than after the decree is passed. This is substituted. So there is a substitute for the promisor. This is substituted performance.
Ma'am, Bhavik Rajni, as performance could be obtained through a third party, would it impact the ability of the arbitral tribunals to grant such relief?
Actually, in substituted performance, the relief asked is money relief. So there shouldn't be any problem for an arbitrator to grant it. But this question actually leads to one more point. Can you repeat the question, Vikas? Can arbitrators?
Ma'am, otherwise on the chat box also.
As performance could be obtained to third party, would it impact the ability of arbitral tribunals to grant such relief? Or should not be any problem. It's a money relief after all. And arbitrators can grant specific performance. That's what Supreme Court has referred to in this case, Olympus Structures versus Mana Vijay Khetan in 1999, followed in a number of judgments later by the High Courts. There's one more question here. In case any liquidated damages are received by the promisee due to deficiency of service as per contractual terms, will it amount to another service performed by the promisee to promisor, or it will be part of the same contract only? I'm asking this with reference to the new amendment post 2018. Now, if liquidated damages are received, it means that promise, if they are for delay, it means that represents the loss for the delay. It is not a separate promise. It's actually a remedy. There are judgments which say that a promise to give liquidated damage is a separate promise. What I think it is a separate clause in the contract, that if A clause is not fulfilled, then B clause of liquidated damages will apply. Even if liquidated damages are agreed, specific performance can still be granted. That is section, I think, 26 or 27. The section relating to liquidated damages still stands. That has not been amended.
Yeah. Ma'am,
very well then.
Thank you, ma'am, for sharing all your insights.
Thank you so much.
It was spot on. You had said that you will take the session around for 55 minutes and then Q&A.
But it went longer. I'm so sorry.
No. I'm saying those questions took up that time. So that's
okay.
That's the hallmark of a successful person.
It's good. It's good to know how people understand the law, the new law.
That's true. That's true. And that's why, though we had done 2-3 sessions, but we always receive.
Anyway, I'll share a secret with you all, that this whole remedy of substituted performance, I don't know whether it's a good one or a bad one, but that part of the law is my baby.
One of your students has written the wonderful section, Advocate Manan, 2010.
Yes, thank you so much. Thank you so much.
And congratulations, ma'am, for all your insights and the way you're moving forward.